I did want to start out talking about you and your accolades, and I mean specifically, you've received numerous accolades during your career, including the California District Attorneys Association Prosecutor of the Year multiple times, and I know that you were commended as being one of the best prosecutors in the LA District Attorney's Office by then Chief of Police Daryl Gates and the acting commanding officer of the Robbery Homicide Division. So I just wanted to know, can you tell me a little bit about your approach when you were on the bench that led to such a successful career?
Well, I wasn't on the bench at the time. I was a district attorney. So I didn't hit the bench as a judge until after 30 years as a prosecutor. I started off as a law clerk for the Arizona Supreme Court. After I graduated UCLA Law School in 1964, I went to Arizona because there was an opportunity to write appellate decisions for the state Supreme Court. So I learned how to do good research and writing. And, you know, I would do the drafts of what eventually sometimes became the written decision with very few corrections. So I had a really good academic background, experience-wise, and working under pressure, which put me in good stead as a lawyer because I was well prepared, and whenever I became a lawyer, to do anything I did because of the research I did as a law clerk for a justice on the state Supreme Court of Arizona. At the time, by the way, I handled a case you may have heard of. I was the law clerk and got assigned a very simple case to decide. An individual committed a rape robbery and was convicted, and his name was Ernesto Miranda. That became the Miranda, the famous Miranda decision. We were reversed. We affirmed his conviction 5-0, and were reversed by the U.S. Supreme Court 5-4. But at the time, we were correct. We followed the laws that existed. They just came down with a whole new method of requiring the police to give somebody their constitutional rights before a confession or admission could be admitted.
And I did want to touch definitely upon Miranda versus Arizona, and just for our viewers of this video, in case they didn't know, that's the law that says you cannot self-incriminate, and everyone knows it as you have the right to remain silent. Anything you can say.
Well, you can self-incriminate, but you can do it spontaneously without being asked any questions. But once you're in custody and under arrest, before the police can question you, if they want to use your statement, they've got to give you your Miranda rights. Right to remain silent, being informed anything you say can and will be used against you in a court of law. If you can't afford a lawyer, one will be appointed for you, and so forth.
Yeah,
that's been the law since 1966.
And I have a question about that. With Miranda, what was it basically that he was coerced into that confession? Is that what happened?
No, we ruled that it was a voluntary confession. They put it on tape. Everything was clear, and the U.S. Supreme Court said in the future, and as for his case, when it was retried because it was reversed, you had to give a defendant who was in custody his constitutional rights, as I just stated. Prior to that, they just asked questions. But most important, they're told they don't have to talk.
Exactly. And I wanted to segue into one of your well-known cases, which was, I know that you were the deputy DA for the Bob's Big Boy murders in Los Angeles, and that I may have this right, but you prosecuted Ricky Sanders and Franklin Freeman Jr. during 4 years of pre-trial motion.
There was also a third defendant, a female by the name of Carletha Stewart, but she cut a deal and pleaded out to 4 first-degree murders with the understanding they'd be concurrent, meaning they'd all run at the same time. So she's faced 25 to life. I've never received any word that she's been released from prison. She took part in the conspiracy to rob the place because she knew the operation of the restaurant, where the money was, what time they closed, what their procedure was.
I see. And I read in the one of the clippings online that the Freeman trial was so contentious, you said, that you fought every day.
Well, actually, Sanders was tried first.
Oh, okay.
And that was the one with Leslie Abramson, who's a very famous lawyer. She defended the Menendez brothers and hung that jury here, the two kids who murdered their parents in Beverly Hills. She had a string of successful cases, and she just a living terror, 5 feet tall and hell on wheels. Draws blood every time you go to court with her. So that was quite a contentious hearing because she was there was a lot on the line. She was a tough defense lawyer. She wrote a book entitled "The Defense Never Rests."
Is it
true? And that case was one chapter in the book. But it was real rough, and we had a pretty tough judge who eventually became a federal judge. And he, when he was sworn in on the federal bench, said he was so happy to be out of the state system because the courts are run a little differently, federal courts versus state court. But he said that trial was nothing but guerrilla warfare every day.
Was it true that the courtroom staff gave you and Leslie a pair of boxing gloves?
Yeah. It was hell. Everyone had a rough time in that case because it lasted, the trial itself, after all the pretrial discovery and the pretrial motions, which took several years, the trial lasted 8 months. That's a long time to keep a jury around. It's a long time to be going to court every day getting a pie thrown in your face, so to speak.
Can I ask you just a question from a layman's terms that the audience may have this question as well? What caused it to drag on so long? I mean, was there something?
There were a lot of witnesses. There were a lot of witnesses, and there was some highly technical defense motions that had to get before the jury regarding gunshot comparisons, pellet comparisons from his shotgun. It just was a long, long trial. Those things happen. And let me tell you something else. It took two months to get the jury because in those days, which we don't have anymore, we had what was known as HOVEY, H-O-V-E-Y, jury selection, which meant that instead of questioning the jurors as to their qualifications to sit on a case like that and their willingness to be fair and impartial to both sides, in a group, they were what was known as sequestered. Each person was questioned for an hour or two every day. We went through hundreds of jurors. That just took 2 months. By the time that was over, everybody was so tired. The idea of trying a case seemed ridiculous. But, that was the next stage. So it was a real endurance matter.
Yeah, it sounds like it.
And then the second defendant, Franklin Freeman Jr., that took us 6 months to try. Separate. It was severed from the other defendant, Sanders.
Oh, I see. Yeah, it sounds really
And Freeman Jr. was from an interesting family. His brother had already been convicted in a totally unrelated case of first-degree murder, killing a judge's mother.
Oh.
Yuck.
What was one of the was it Freeman who initially was held up to high regard because he helped what was it?
No, that was Hawkins.
Oh, Hawkins. Okay.
That was the Hawkins drug case. I'll talk about that when you're ready.
Okay, good. Thank you.
Anyway, on this particular case, it's the only case in which Leslie Abramson, the defense lawyer, ever had a death verdict against her client, and she tried many, many death penalty cases. She'd never had one, never lost a client to the death penalty. Of course, the defendant's still on death row with another 720 people waiting to be executed. What's going to happen in that regard, I don't know. Probably outlive me.
And that was in 1981, was it?
82, I think.
82.
The California Supreme Court affirmed the conviction and the death penalty, I think 1995, and it was a unanimous decision. And a liberal judge wrote it, Stanley Mosk, who was the California Attorney General before he was on the Court of Appeal and then the State Supreme Court.